Okay, so yesterday we have started with the conditions, and wherein we have discussed that conditions can be express conditions और implied condition. And legal rule हमें पता है कि अगर condition हमारी fulfill नहीं होती, then the buyer has a right to set aside the contract. And when he set aside the contract, repudiates the contract, he can claim the price as well. सो व्हेन वी टॉक अबाउट एक्सप्रेस कंडीशन, तो एक्सप्रेस कंडीशन वो कंडीशन होंगी जो सेलर और बायर आपस में डिसाइड करेंगे. बट इम्प्लाइड कंडीशंस वो कंडीशंस हैं which are given in your sale of goods act, which are given by law, and these are also required to be fulfilled. So if the condition, whether express or implied, if these are not being fulfilled, then in that particular situation the buyer have got the same right, that is to repudiate the contract and also to claim the price in case of the contract. So here we have already discussed these implied conditions, so we'll just revise these conditions quickly. That the first condition is condition as to title. So when we talk about sale of goods act, ownership is the prime requirement which should be transferred from the seller to the buyer. So if there is failure in fulfillment of this particular condition, then in that particular case, the buyer has a right to set aside the contract. So whether this is a case of sale or it is a case of agreement to sell, in both the situation, the ownership is to be transferred from the seller to the buyer. तो अगर वो ट्रांसफर नहीं होती है तो उस केस में हमारी implied condition as to title fulfill नहीं होती, and in that scenario the buyer has right to set aside the contract. In continuation we have discussed that there is implied condition by description. तो जहां पर भी हमारी goods, sale of goods according to the description of the goods हुआ है, तो उस particular case में गुड्स जो है वो डिस्क्रिप्शन से मैच करनी चाहिए. अगर वो गुड्स डिस्क्रिप्शन से डिफरेंट होती हैं तो उस पर्टिकुलर केस में इम्प्लाइड कंडीशन एज टू डिस्क्रिप्शन फुलफिल नहीं होती, एंड द बायर गेट्स द राइट that condition is not being fulfilled and there is a breach of condition, then the buyer can set aside the contract. But in this particular case there are two exceptions where there is the doctrine of caveat emptor applies, and where the buyer has not relied on seller description. Seller has described the goods but he has not relied on the description. तो वहां पे गुड्स जो है एज पर सेल बाय डिस्क्रिप्शन की कैटेगरी में नहीं आएंगी और वो कंडीशन फुलफिल नहीं होगी. But this particular case of description where it will apply, where buyer has not seen the goods or buyer has seen the goods as well, but he relies not on his own judgment or what he has seen, but what has been stated to him. So in this case अगर description से goods deviate करती हैं तो buyer उन goods को set aside कर सकता है. Next condition we had discussed, condition in case of sale by sample. So here the goods must correspond with the sample, and second thing is that the buyer should get reasonable opportunity to inspect the goods or to check the goods with respect to its compatibility, that whether it matches with the sample or not. So herein I have given you the example of the colors of the dress material, and we have discussed the example of a particular part which is to be fit into machine. So what is the reasonable time period to even the acceptance of these goods will not make the buyer will not lose the right that he has accepted the goods or he has kept the goods, so it means the contract of sale has been performed. No. In case of sale by sample, the buyer should have the reasonable opportunity of comparing the bulk with the sample. Otherwise, the condition as to sale by sample is deviated and not been fulfilled, and buyer has right to set aside the contract. Then there was a condition that where the sale is by sample as well as by description. So in this case, the goods must correspond with both, and if there is deviation even from one thing, then the condition as to the requirement is not being fulfilled. Then the next condition is condition as to fitness or quality. So we say that there is no specific condition with respect to fitness and quality. So here it would depend upon the buyer that what is the purpose of buying the goods, whether he has selected the goods properly or not, and here the doctrine of caveat emptor will apply. But in the case where the buyer has specifically told the seller expressly or impliedly about the purpose of the goods, and also he has relied on the seller's judgment and skill, and seller is dealing in those goods therein the purpose, the goods must be fit for the purpose, and if turn out to be unfit for the purpose, then the buyer has set a right to set aside the contract, and there the doctrine of caveat emptor will not apply. And also in case there is the we can say the description must have been given by the seller, and whether the particular person is expert or not, all these things have to be taken care of in case of we are taking the exception from doctrine of caveat emptor. Then the next condition is condition as to merchantability. So here the goods must be fit for the purpose for which these are commonly bought. So reasonable quality honi chahiye, right? Reasonable quality के साथ साथ fitness of purpose होना चाहिए. So fitness of purpose not in the sense that whether it fits for your purpose or not, but fitness of purpose here means कि जिस particular purpose के लिए जो goods है वो commonly purchase की जाती हैं. Then in continuation, condition as to wholesomeness, here we have discussed that where the goods are in terms of eatables and provision, then in that particular case it should not be harmful for the human consumption, and the goods must be as per the requirement and reasonable quality and free from any defect which render them unfit for human consumption. So अगर इन conditions में से कोई भी condition आपकी satisfy नहीं होती है, then the buyer has a right to set aside the contract. And last one we have discussed that a condition implied by custom. So in this particular situation, if we talk about along with the other condition, if certain conditions are being attached, which are as per the usage of trade, then in that particular situation, the particular condition will also be applicable in that scenario. Now moving towards the warranties. So when we talk about the warranties, so warranties can be express warranties or implied warranties. Express warranties are those terms and conditions which are decided by the seller and the buyer at the time of formation of the contract. If we talk about the meaning of warranty, so we say that these are the related requirements or conditions in the contract must be fulfilled, but non-fulfillment does not give right to the buyer to set aside the contract. Doesn't give right to buyer to set aside the contract. What he maximum can do, he can just claim the damages for non-fulfillment of those warranties, those terms and conditions. So if we talk about conditions are related to the main purpose of the contract, the basic purpose of the contract for which the particular contract has been created. So when we talk about the implied warranties are those warranties, those terms of condition which the law presumes to have been incorporated in the contract of sale. Right? So in this case, other than the express warranties, implied warranties are there given by the law, given by the Sale of Goods Act. The very first warranty is warranty as to the possession, whole possession, total possession of the goods. So in this particular case, we say that whenever the sale happens, the sale or the ownership can be transferred either by possession of the goods or by documents of title, and it can be by both. But in this situation, if the possession is not being given and documents of title are being given, the possession must be given to the buyer. So buyer have the right to take the possession of the goods. So if these are delayed or any expenditure is being incurred, then in that particular case, the buyer has the right to claim the damages for that. So if warranty with respect to possession is not being fulfilled, buyer doesn't get right to set aside the contract, but he can claim the damages with respect to the non-fulfillment of this particular condition. So, for example, the goods have to be procured from A's godown, right? The sale has taken place and the payment has been made and the documents of title have already been given. But this particular A is not able to give the possession of the goods, or it just got delayed because there was the extra consignment was not coming and there was additional expenditure of rupees 2000 for bringing the goods to the buyer's place. So in this particular case, if buyer collects himself, he can claim this damage, or he can he can ask A to bear this particular expenditure for the possession of the goods. So implied warranty with respect to the possession is important. So in this case, if any the other person interferes or having superior right or title than the seller, then in that case buyer have the right to get the goods, and any kind of money or expenditure which is being borne or any kind of damage which is being suffered by buyer, he can cover it from the seller itself. Second implied warranty is freedom from encumbrances. So if the goods have been pledged with someone or the goods have been kept with someone for some specific purpose and the other person have given the possession after making some payment or certain expenditure have been incurred to get the possession of the goods, then in that particular case, such an expenditure is to be borne by the seller. So it is also said that goods are not subject to any kind of charge or favor in favor of the third party. So if buyer's possession is disturbed in any ways with the existence of any charge or encumbrances on the goods, then he shall have the right to claim damages for breach of this warranty. So seller would be responsible for the same. Then another thing is warranty to disclose dangerous nature of the goods. So if the goods are inherently dangerous, the buyer is ignorant of the danger, the seller must warn the buyer of the probable danger. And if the seller fails to do so, the buyer is entitled to claim from him any compensation for any injury suffered by him. In this particular case, we have to, when we say that telling the danger, so generally it is written on the goods that the goods are injurious to health, the goods to be kept away from children, right? Or it is carrying the flammable item or all these things. So it is there. So there is one also case law that where A has purchased a bottle from a particular shop and this bottle was required to be open in a specific manner, or a specific opener or specific thing was required to open the particular bottle, and this has not been disclosed by the seller, and while opening the bottle it burst and the hand of A was burnt or injured. In this case, it was held that the seller is responsible for the damage and for the loss suffered by the buyer. So in this case, if there is any inherent dangerous nature of the goods, it must be disclosed. So if the particular, we can also ask a question here that if it, in case of the medicine or any products, it is written on the particular item that this particular item is to be used in this particular manner. So if the other person is illiterate and he cannot read and write and he cannot understand the terms of the condition, then in that case, it is the duty of the seller to communicate it verbally about the dangerous nature or how to use a particular product. It is the duty of the seller. Then last one is warranties implied by the custom or usage of trade. So if any, as per the usage of trade, any benefit or any other thing is being attached by the custom of trade, then in that case we can go with that. Then there comes that whether we can exclude the implied conditions or warranties or not. So in this particular case, we say that it is for the benefit of the parties. So by the course of the dealing between the parties, if they want to, bind both the parties to the contract, or if there is any implication of law which is by express agreement they want to exclude, then they can exclude the any of the warranty. So that must be excluded by the express contract, by course of dealing between the party, or by the usage of trade. So sometimes we transfer the goods, but the other person keep on using the goods, and the goods are in the possession of the seller itself. So that does not matter. So it depends upon the understanding between the seller and the buyer, that whether they want to continue with the goods or with all the implied conditions or warranties or not. So let's take a pause here, and then we will discuss the doctrine of caveat emptor. Let's discuss the questions or doubts till now.